Yes, Simon. Yes, Simon.
Good morning, Judge Shamlan.
Morning. I was in the wrong link, I guess.
My apologies for that.
That's fine. Thank you.
Okay. The hearing in this matter is being held by way of teleconference. Any orders or directions made after or during the course of this hearing will be issued by the Registry in Dubai on His Excellency Justice Shamlan Sawalehi's instructions. The hearing today is in the matter of CFI-070-2018 before His Excellency Justice Shamlan Sawalehi. The claimant is represented by At-Tamimi & Co. And lead counsel is Patrick Dillon Malone, SC. The defendants are represented by Onuma FZE, and lead counsel is Faisal Osman.
Just want to clarify this. This is the second defendant is not represented. Is it today? Is it right?
That's correct.
Good. Ayman, you would like to make any introduction about guiding me through the e-bundle?
Judge Shamlan, I've spoken to the parties and they will give you the numbers in the top right corner, or alternatively will direct you to the page using the direct others to page button.
All right, that's perfect. Maybe you've been asked by the registry how long each party would like to take, and the reason for that, we have an urgent application at 2 p.m. Dubai time. So I would be grateful if we can finish maximum by 1:30 for all submission and reply. Is that okay?
We'll certainly do our best to help.
Yes, Judge. That should be no difficulty.
Good. I think we can start with Patrick from Al-Tamimi.
It's the defendant's application, Your Excellency.
Yes.
Yeah, it is in fact my application.
Yes,
and
sorry. I apologize. Yes.
Not a problem at all. It's always difficult over video because you can't see anyone face to face. But
yes.
Can I start by making just some brief introductions? I think you know my learned friend. I am for all defendants apart from the second defendant, and I, together with Mr. Fedrigoli, Tamimi's for the claimant, and you'll know and recognise Mr. Malone, who's assisted by Mr. Owner. Can I just quickly deal with what material you should have in front of you? There are 3 bundles. The first one is HB1, Hearing Bundle 1.
Yes.
The second is HB2, Hearing Bundle number 2.
Yes.
And the third is an Authorities Bundle, AB1. There's just one Authorities Bundle.
Yep.
You should also have 2 skeleton arguments, one from myself and one from my learned friend for the claimant.
Yes.
And in relation, we've spoken to your associate previously. I am going to direct you page number by the big red numbers on the top right hand corner of each bundle, and the internal numbers, which are on the bottom right, I'm going to ignore. So if I ask you to turn to a page number in any particular bundle, it will be HB1 and then the number on the top right hand corner, and hopefully that should work out, I hope, quite well and quite easily. With that in mind, can I just make some introductory remarks? The first is that we have covered a lot of ground in our respective skeleton arguments, and hopefully you've had an opportunity to review those skeleton arguments and understand the shape of what it is that both of us are saying. The evidence in this case for this type of application is, may I suggest, quite comprehensive. And on that basis, may I suggest that you should have a good idea of the shape of the claim and the application and what it is that the claimants say in reply. My aim for this application is to try not to repeat what's been said in the skeleton arguments, of course not, but to try and draw all the relevant issues together and focus on a few key points which I will explain. And to help you, may I respectfully suggest that the order of how I'm going to set my submissions out may be of assistance. And here is that order. What I will do first is I will identify the relevant test which your excellency is going to have to apply. Secondly, I'm going to set out the structure of my submissions, and there are going to be 5 submissions. Thirdly, I will just touch upon the procedural history, how we got to this point, but I'll be very brief about that.
Yes.
The thing I will do is I will develop the submissions which I have identified and will do, and finally I'll reply in due course. So to the first of those menu items, if I can call them that, the first is the test, and I'm going to proceed, and I think both of us, myself and my learned friend, know this because we've had a good look at the authorities, that you are familiar with applications like this. And you'll see perhaps in the authorities bundle that in fact there are, I think, a couple of authorities where you have presided. And you will know, therefore, because you have dealt with applications such as this, that what we are seeking here, an application to set aside judgment in relief, is a discretionary form of relief. Can I ask you kindly to turn to the authorities bundle, and for convenience sake, for here on I will call the authorities bundle AB. So that's AB3, so the third page in the authorities bundle.
So can you give me the red color number?
3.
I see.
This is where I hope the technology works.
Hopefully, yeah. Okay.
The document should read Part 14, setting aside or varying judgment, default judgment. Is that correct? Is that what you have?
Yes.
Excellent. So the technology does work. I'm very pleased. This is the test. We're not looking at 14.1. It's not a 14.1 scenario. It's a 14.2 scenario. And just a few moments, if I can read it, if you'd allow me. 14.2. In any other case, the court may, and that is the discretionary part of the test, may, on such conditions as it sees fit, set aside or vary judgment entered under Part 13, which of course is judgment in default. And here are the conditions. Number 1, the defendant has a real prospect of successfully defending the claim, or it appears to the court there is some other good reason why. 14.3, as Your Honour would have no doubt recognised through the skeleton arguments, is a matter which will be of some focus. In considering whether to set aside or vary judgment under Part 13, the matters which the court must have regard include whether the person seeking to set aside judgment made the application to do so promptly. And the other aspect that I would kindly ask you to bring your attention to is the very next paragraph, application to set aside or vary judgment, the procedure, an application under Rule 14.2, which is this, of course, must be supported by evidence. And the word must is important. That is mandatory. It is a requirement. So that's the test. And that's the starting point and indeed the end point in terms of determining whether this application should be brought. And I hope that's helpful to zero in and concentrate on the test before going any further. That's the first menu item on my menu. The second menu item is the structure of these submissions, and this is how I'm going to structure the delivery of what's to be said, and a summary of each of the 5 submissions. My first submission is as follows. The order of the issues that the court must determine in Part 14 is very important. And what I mean by that, if you still have Part 14 in front of you, is that the first task that the court has, is to determine whether the defendant has a real prospect of successfully defending the claim, and then following that, 14.3, following, the court must have regard as to whether the application was prompt. And the order in which that is done, I will explain, is important. I'll explain why that's important with reference to the law, and give you the practical and thematic reasons as to why that is important on the basis of principle. My second submission is this. Here, the defence case is more than merely fanciful. It's a serious dispute. The words "more than merely fanciful" are not words I dare suggest that will be lost on you. You will recognise them, being an experienced judge in this jurisdiction, having dealt with this application before. But "more than merely fanciful" appears to be the words that have adopted their own importance, even though they don't appear in the actual test of 14.2. But again, my second submission, I say the defence case is more than merely fanciful, it's a serious dispute. And just some points about that submission. It's important to note how high the bar is that the claimant has set for itself. What they are saying in this case, and I will use the short acronyms for the names, is that AKM, who's the patriarch of the family, is dishonest. They say he's lying. They're also saying that about his daughters. I'm not entirely sure what they say about the other witnesses who also work at the company, who've given evidence, and Your Honour will have seen that evidence in the hearing bundle, but that's how high they're putting the case. They're saying he's not telling the truth. They are not telling the truth, forgive me. The law is clear on what should happen and what the court should do about evidential disputes at this stage of this type of application. And I will identify for you what the law says about how you handle evidential disputes between the parties now. But on any view, and this is a phrase that no doubt you will have picked up from my skeleton argument, the two parties are diametrically opposed. There's very little middle ground, one on one side and the other on the other side. At the end of the day, and it is as plain as a day, this is a traditional classic trial dispute. And the only way to resolve who's right, whose evidence fits together, whether witnesses are lying, is through the trial process. And again, the law is clear, but in any event, Your Honour, with respect, you cannot possibly make findings of fact based on the witness statements, and arguably from the claimant side on two partisan witnesses alone. You need a trial, one needs a trial to work out what the true position is in this case. Third item on the menu, promptness. Promptness is an assessment on a case-by-case basis. And in this case, we say the defendants were right to take the approach that they did in the context of what happened. A couple of quick comments about promptness. Promptness is not a fixed term. not defined in the rules. And I want to give you a good example of how promptness is applied in different cases. Can I ask you to kindly turn to AB 071? That's 071, top right hand corner. Do you have the case of Strachan and Gleaner in front of you, Ron?
Yes.
Thank you. Can I just, without going through the authority in excruciating detail, can I ask you to scroll your eye more than the page down to F on the right hand side?
Yes.
Paragraph starting held. This Strachan and Gleaner is a Privy Council case, so as about a higher court and the land is certainly in the jurisdiction where I am currently sitting that one can possibly get. The law, and it says this, the law to set aside default judgment on liability could be exercised notwithstanding that final judgment has been given in a liquidated sum, since that default judgment was not spent or superseded by the judgment on damages. What does this mean? Strachan and Gleaner is an example of a case where even when liability had been determined, judgment and default had been applied before a damages assessment, and that the Privy Council said the jurisdiction was upheld for that to happen. So here is one example of the flexibility of what promptness means. It doesn't mean at one time or the other. I can put it this way, and I don't think my learned friend will push back too hard. It all depends on the facts of the case. Promptness depends on the facts of every single case. And that is as much assistance as the rules unfortunately have given you. But the reason for that is because this is discretionary, and you have to, with respect, carry out the exercise of determining not just whether there was promptness, but what that promptness means for the application. I will explain in due course that the first, in respect of promptness, the first thing that the defendants did was to instruct the handwriting expert to determine whether the defence meets the standard to discharge. And we say the claimant is wrong when it says the application should be made first and then handwriting evidence comes later. An application should only be made to discharge when there are grounds to do so. And that is why I took you to part 14, where it said there must be evidence in support of the application. And in fact, in this case, the defendant's decision to seek a handwriting expert was vindicated, because they're saying that he's lying if you just took him by himself. And it's not merely luxury, it's the heart of the matter in this case. And what we say is that on the defence case, in fact, what's happened is the defendants and the companies have been subject to fraud. And the court should proceed on the basis that there's a reasonable chance that has occurred. And it would be wrong when assessing promptness to ignore the extraordinary pressure that the defendants have given evidence about. And I'll show you that evidence in due course. Submission 4, briefly, what do you do when deciding about delay? How do you approach delay? And the court needs to look at 4 issues, I say. What's the purpose of reviewing delay? Does the delay indicate a lack or absence of sincerity? And does the delay undermine the process because it is so egregious, so bad, it shouldn't be allowed, even when there is a case to be tried? And the 4th point, when you come to look at delay with respect, is a question as to what prejudice the claimant has suffered. Is it so great that it would be unjust to allow the defence to bring its case, no matter how much a trial is called out for? And I'll deal with each of those submissions in turn. And finally, the fifth submission is a conclusion, really. We say that the discretionary process of allowing relief under Part 14 is a balancing act. But that balance must weigh in favour of the court exercising its jurisdiction to hear and determine genuine disputes. And our headline is this: on any view, this case is a case which needs to be examined properly. And it would be unfair, ultimately we say to both parties, for the claim to end prematurely without getting to the truth of the matter. That is the process and the objective of a dispute resolution forum such as this court. I said I would deal with the procedural history, and I will do, and I'll be very brief. I'll be brief because what we have done, I say we because this is a jointly agreed bundle, is set out the orders in this case in the bundle, starting at HB 1179. So that's HB 1179.
Yes.
And you'll see that's the default judgment by Judicial Officer Al-Bahiri. And that's the judgment which sets the process off. The journey for this application has been a bit, I was going to use the word peculiar, but that would be unfair, different, insofar as that there was at one stage a de novo review of an application which was granted to set aside judgment in default. What do you do about that? Well, the de novo review is just that. It's as if it didn't happen. So anything before the de novo review, we couldn't and wouldn't invite you to take notice of that. It's as if the clock has reset. After the de novo review, there was a review that took place, and on that basis, the registrar applied her mind as to whether the evidence, after both parties had served their evidence, was sufficient to have the application granted, and the application to set aside judgment in default was granted. However, the claimant was right that it had an opportunity to be heard before a hearing. That's this hearing, and for that reason, the application to set aside was effectively removed from the court file. The short answer is this: this application is entirely a matter for you, and you're not bound by any other previous registrar's decision. It's as simple as that. But it's worth just clarifying because the history has been slightly different than it would be. But that's the steps that have gone through before we've got to today. I don't need to say any more about that, I suggest. Can I then dive into the submissions?
Please go ahead.
Submission is the order of issues, as I said. So submission 1, order of the issues. Would you be kind enough to turn to AB 1007?
AB 007.
Yeah, 7, like James Bond.
Yes.
You may recognise the name and this authority.
Yes.
It's paragraph 10, an encapsulation of what it is that the court has to look at in respect of the first question. Paragraph 10, real prospects of success means realistic rather than fanciful, and it's the authority of Swain and Hillman, which will feature again. This is a matter of judgment in each case. I'm inclined to find that the defendant's arguments regarding jurisdiction, and this was about loan agreements, you may recall, the application should be set aside, etc. So the realistic prospect of success was the starting point there. It's the starting point. Look at realistic prospects of success first. And the reason why realistic prospects of success is looked at first is it's intentional. The rules set it out that way intentionally. The court must look at the disputes before it decides how to proceed. It's not correct that a delayed application is an application that cannot be made. Otherwise, and this is important with respect, otherwise delay would become first and would be determinative. It's not that way round. Arguable case, forgive me, realistic defense comes first, not delay. And I won't take you to it because we'll be jumping around pages and it become quite irritating. But if one went back to the test in part 14, again, point 1, does the defendant have a realistic prospect of defending the claim? The next sub consider whether there is promptness. So there is an order in which these things must be done, we suggest, and the order and the reasons for it are obvious. The importance is the importance of the case as opposed to the delay. That takes primacy. The priority, and I call that the priority of looking at the case, is not absolute. Of course, the court must not allow defendants to delay as a tactic. Of course, I accept that, because that would undermine the process. And that includes prejudicing the claimant from proving his case because it's become stale. Is the defendant doing that? Is he prejudicing the claimant's case by making it go stale and making it difficult for the claimant to prove his case? And all the case law is consistent with that approach, i.e., look at the real prospects of successfully defending the claim first, then look at delay as part of the consideration of the balancing exercise. And if that balancing exercise in respect of delay forces you to find that there's been a cynical application made by the applicant, the defendant, or is trying to gain an advantage, the fact that there may have been delay becomes more important. And so I hope this assists. What I've done is effectively created or distilled a decision flow of how the court should approach this particular application. The first question, is this a genuine dispute? If the answer is no, that's the end of it. If the answer is yes, this is a genuine dispute, does the dispute call out for resolution at trial? For example, are there witnesses that need to be cross-examined? Are there issues that need to be put? Is there disclosure, etc., etc.? If yes, the court should proceed on the basis that justice does require a judgment on the facts. That's not the end of it. If the defendants have given up the opportunity to have their case vindicated at trial because it's made an insincere application to put off enforcement, or they've tried to undermine the court's ability to dispense justice by delaying the application such that the claimant would be prejudiced from presenting his case now, then in all those circumstances, that delay, which is cynical or divisive, would arguably dislodge the need to have a genuine dispute tried on its merits. And you will recognize that, I suggest, by what is said in the Sawalehi Eagle. And that's, just very briefly, Authorities Bundle 1, page 33.
Yes.
The Sawalehi Eagle is a very well known, but it's a slightly old case now. But can I summarize it in this way? In this case,
briefly, yeah.
Yes, briefly. But in this way, effectively, the defendants in the Sawalehi Eagle case were being cynical in terms of making their application to discharge. And even though the court should look at the merits of the case, it concludes by saying this. Page 37, the conduct of the defendants in this respect, in deliberately deciding not to give notice of intention to defend because it suited their interests of the group to let the plaintiffs proceed against defendants, should be taken into account when assessing the justice of the case. So what it essentially says there is that you may have a case at trial, you may have reasons for the case to be tried, but if you're being cynical and you're trying to be divisive, then then the delay aspect of it starts to become very important. Well, in this case, the claimants have the allegation that the defendants have been insincere is just baseless. On the contrary, this is a genuine application which was made with more evidence and on a further basis than most applications to set aside judgment in default. There's handwriting expert. There's other witnesses as well. This is a properly made application. And there's no evidence to suggest that if there has been a delay, that delay has caused the case to go stale and that the claimants are in some way harmed in establishing their case at trial. That's just simply not the case. It's not a Saudi Eagle case. So we can put that, may I suggest, to one side. And then this is really what the claimants are saying. The claimants are saying, look, we have a standalone right to finality. And our right to finality is superior to the defendant's rights to have judgment on the facts. We say that's a skewed view of the way in which the law operates. And what the claimant's real complaint is that this application prevents them from having expedited judgment, denies them the opportunity to have judgment now, as opposed to the ordinary way of having judgment after trial. And so that's really what it comes down to. Respectfully, it's rights to finality versus rights or necessity to have this case done at trial. Can I deal with one aspect which hasn't really featured but is important for this purposes when I talk about the rights to finality? And that's this. And I dare say you want to pick this point up already. The rights to finality must be looked at through the prism of what's happened to Heliopolis, the second defendant. Because, and I will be corrected if I'm wrong, and I'll deal with this in due course, but this is not a situation where the claim will come to an end at the end, if you are against me, of this application. There's still a claim in respect to the second defendant, and I'll deal with that in more detail later on. But I do ask you to have that in mind when looking at the complaint that, in fact, the claimants are entitled to finality when looking at what's going on with Heliopolis. I'll speed up slightly. The second submission I have is, what does more than really fanciful mean in terms of defence? Really, merely fanciful means a real prospect of defence, of course. It's not defined in the rules, but there may be some help that I can give you with that definition. More fanciful means that it's just not good enough to merely deny the claim. You've got to do more than that. There must be a basis for that denial and support. In this case, it's absolutely plain that there is more than just a fanciful defence. And the reason I say that is for the following short reasons. There can't be any real doubt that there was a fraud at DEG by the ex-managers. And you will see in the witness statements with reference to exhibits that the Abu Dhabi police have already investigated what's happened to EEG. And they have found that there was a fraud. They have found that there was forgeries in relation to the company. They have found that, in fact, there were improper and unexplained payments to third-party companies, which just don't make sense. Something was seriously wrong. It was worrying. And the companies collapsed because of two individuals who have left, fled the jurisdiction and gone. So this is not an occasion where the existence of fraud is just a figment of the imagination of the defendants. Absolutely not the case. And the Abu Dhabi police have looked into this. The question is, does that forgery extend to the IDBI facility? Is that right? That is a trial question. Dr. Al-Bar has carried out a careful forensic examination, and you've had responsive evidence from Miss Barr, Catherine Barr, in response to that. And the two witnesses say different things. That is a dispute. That is a matter for trial, but more than that for this purpose. It's more than a fanciful defense. Dr. Al-Bar's evidence is more than just a fanciful defense. It's something which needs to be determined. And I won't go through it, but no doubt Your Honour has, the way in which Dr. Al-Bar has conducted his exercise is careful. The analysis is careful. The amount of handwriting samples is careful. He's taken care. And what he said at the end gives rise to serious questions as to whether the handwriting that are on these documents was the handwriting by these defendants. And there can be no doubt about the fact that he has raised that issue. It is more than just a mere fanciful defense. But there are factual witnesses as well that call into question the claimant's version of events. This is a classic witness versus witness dispute. But the point is that there is evidence from those witnesses, which is more than just a fanciful defense. And the law is clear. You should not, with the greatest of respect, carry out a mini trial. Briefly, Authorities Bundle, page 21. 21.
Yes.
And this authority is, I suggest, very useful and important. It's an authority from this court, it's GFH Capital, which you will no doubt recognise that it's a slightly infamous case, as you well know. Mr. Justice Giles, but Mr. Justice Giles, as is his way, at paragraph 9 on page 21 and the subparagraphs, has, may I suggest, very helpfully dealt with 10 points in respect of the approach the court should take on immediate judgment. Court must consider whether the defendant has a realistic prospect of success. He's defined what realistic prospect of success is. There must be substance in the facts. The court should avoid being drawn into attempt to resolve those facts, which should normally be resolved by the trial process. So that is a very useful summary of how to deal with immediate judgment. That, of course, is to do with Part 24 applications by claimants as to whether there should be summary judgment. But the principles are the same. The only difference is, in this situation, it's flipped because there is a application to discharge judgment in default. But the tests in terms of immediate judgment are the same. The point is this: the law is clear that the court at this stage should not conduct a mini trial. And the reason for that is absolutely obvious, almost so obvious it bears not saying, and that is that we haven't been in a position where we're able to have the proper disclosure process, the proper pleading process, the proper witness cross-examination process, and it would be a disservice to the case to carry out a mini trial, and the courts have been quite clear that that must not happen. So the summary is this: is this a case where there is a more than fanciful chance of a defence, a real prospect of the defence? Absolutely, of course. Absolutely. No question about that. How do you resolve it? It can't be resolved now. It has to be resolved at trial. But we passed that gateway clearly. Now, whatever my learned friend says, well, he can't be telling the truth because of X, or this document says Y, or this witness said something completely different. Every time my learned friend says that, he demonstrates why there has to be a trial. Because this cannot be resolved now. If it cannot be resolved now, it has to be resolved at trial. I just want to make one note of caution. It's the issue in this case is not whether there was a facility agreement at all, but how and when the facility agreement came to be, and whether the defendants agreed to secure the facility personally using their own wealth, personal guarantees. It's a narrow issue than that. Can I move forward then? I don't have to. I'm just keeping an eye on the time as well. I'm conscious of that. Just to deal with this, there are some unanswered questions in this trial, in this case, again, which point towards a trial being required. How does the claimant reconcile the fact that the patriarch, AKM, was not in the country at the time of the alleged meeting? We haven't been able to explore that. How does the claimant deal with the signatory for Heliopolis, which was supposed to be under judicial guardianship in 2009? Nothing said about that. What was the bank doing in terms of diligence when these fraudulent transactions appeared to be made? There's been no engagement on that. That's not a criticism, it's just because we haven't got to the stage of trial yet. What's the position in relation to the security checks, which are now demonstrably forged? And this is the most important aspect, what exactly was said at this meeting that the claimants rely on? What contemporaneous notes are there? What was understandings between the parties? This is a central aspect of the claim. And there's no possible way that it could be dealt with without a trial. And that's where this case must proceed. And in fact, the claimant's case hinges on the two witnesses that unequivocally say, well, AKM's not telling the truth. And again, at the risk of repeating myself, and forgive me, this is a classic dispute which must be determined at trial. And all that the claimant's evidence and submissions do is emphasize the fact that it needs to be dealt with properly. Promptness and how the court should approach issue of delay. I'm going to deal with these together for the interests of time and because I can. And these really are the last substantive points I have to make in relation to submissions. The approach the court should take in relation to promptness is as follows. In all the circumstances of the case, could the defendants have acted more swiftly than they did? If yes, they could have acted. If yes, they did act as swiftly as they could. If they did act as swiftly as they could, that's the end of it in relation to your consideration of promptness. If you decide that they did not act as swiftly as they could, I invite you to move on to the next question. The next question is this. If the defendants did not act as swiftly as they could, is that failure so egregious that the obvious needs to have a trial should be disregarded? So egregious. And on what basis would it be so egregious? The defendants would lose their rights to be heard, one suggests. Again, if they're trying to use the process to delay enforcement cynically, or they're trying to take advantage of the case going stale. That's not what's happening here. That's not the position. So therefore, I suggest that one needs to move on to the next question. And that's this. Is the bank's right of finality more important than the trial in these circumstances, such that judgment in default should remain? If the answer to that is no, if the right of finality is not more important than the right to have the matter, important as it is, heard at trial, If it's not as important, the application should be granted. And that hopefully is an easy walkthrough of how to approach the issue of promptness. And if I've not made that clear, then please tell me, because I will attempt to do a better job.
No, you are clear.
Thank you. Were they acting swiftly? Well, look, the reality of this case is that the whole group had collapsed because of the fraud that's taken place. And as AKM, the patriarch, has explained, the family was confronted with a tsunami of civil and criminal litigation. And there's extraordinary pressure, and that's not an excuse. That was the reason for why what happened. And they were, in his words, trying to deal with survival. And a retrospective view of whether they should have done this at this time or that at that time, it doesn't reflect the reality of what took place. This was crippling against the family. And if it's a criticism that they should have moved more swiftly by a couple of weeks, one has to ask whether that really is a criticism of lack of promptness or sincerity, or just them being victims as to the circumstances which befell them. I won't go through it in detail, but AKM has dealt with this extensively in his witness evidence. And I'll give you the page reference numbers. Hearing Bundle 1, page 39 to 40. I don't ask you to turn up for the interests of time, but in those paragraphs, AKM has explained what on earth was going on effectively and what he had to do. He's also got a second witness statement, same bundle, page 152. 152. Yes. And in that witness statement, he's explained that there was, in fact, more fraud that's been found since his first witness statement. So that gives you, respectfully, the context of what on earth was going on at that time. And it was serious. It was serious and it was troubling. It's entirely distinguishable from the rest of the cases that have been put before you in terms of the authorities. What do? They went to Dr. Albar first to get a handwriting expert. And may I suggest they're right to do that, because the application has to be supported by evidence. And you've seen it's quite clear the reaction that the claimants have given this application by saying, well, they're just lying. But the need to get an independent handwriting expert, because they were no doubt to be confronted with the allegation they were lying, was the right thing to do. So the priority to do that was the right thing to do. And that's not a question of delay, that's a question of wisdom in terms of how to approach this application properly. My learned friend seems to hone in on the fact that there's been a prioritization of monies to spend in this place or that place, and not in relation to lawyers. The position is this: it's quite clear. They didn't have enough money to do everything all at once. There was a prioritization. That prioritization was Dr. Albar. That was the right thing to do. They put the money later to put lawyers in funds to issue the application. That is a manifestation of what was taking place at the time. It is not an indication of a lack of sincerity or a lack of seriousness in pursuing this application. It is just the circumstances which affected them at the time they had to make this application. And in those circumstances, I submit that you should be slow with the greatest of respect, Your Honour, to conclude that the defendants have acted in a dilatory fashion, as AKM remarks, are trying to survive by the moment. Now, briefly, is the delay egregious? Well, there's 3 points about that. Number one, the law doesn't define a delay which is too long. And that's intentional. Every delay has to be dealt with on the facts. Number two, the relevant time is from when Dr. Albar received the material to carry on his work, which was from November 2019, and that work was completed by April 2020. Is that delay so egregious that it should shut defendants out from defending their claim, which clearly ought to go to trial? I've dealt with the extraordinary pressures. That has to be determined when you look at whether the delay was so egregious. The test which you ought to apply, may I respectfully remind you, is not whether there's been delay per se, but the need to control the process, the need to control the court process. And again, there's no suggestion that the court process needs to be brought back into control because the claim is going stale, or that we're trying to score an unfair advantage. This is not a tactical device. No matter what the claimants say, it doesn't make sense to be subject to judgment in default and have to make an application to discharge it. It just doesn't make sense at all. The truth of the matter is as how it has been presented. This is what they're confronted with. Judgment of default was issued. They now did what they needed to do in the circumstances and the resources they had to put it to one side. So this, finality. Is finality the trump card? Well, the law's obvious, it's clear. Justice is better if judgment is given on the facts. That, I agree, should not be open to abuse, and it's not open-ended. But I've dealt with Heliopolis here, and I said I will return to it, because I submit that it undermines a claimant's plea that it is suffered from an inability to obtain certainty in this case. And you've already noticed that the second defendant is not an applicant in this case. And that's because Heliopolis has served a defence. In fact, you'll see from the evidence that AKM and the family's knowledge of this claim came from Heliopolis's guardian. And that's when they set out to understand what the claim was all about. It follows, unless I'm mistaken and unless I'm to be corrected, that this claim will carry on against the second defendant. But there has been no explanation as to what the claimants have done to progress that claim in relation to that second claimant to bring finality to the claim. Now, we haven't seen anything that suggests that the claim has been progressed, no listening of a CMC, no application for immediate judgment of some sort or process to trial. And the question therefore is begged. On one hand, if there is a complaint about a lack of finality, I invite you respectfully to ask what is going on with the claim. And has there been a commensurate, expedited move to act with finality and speed in relation to the claim? Because if there's not, it does undermine the claim to finality which the claimants rely on. In other words, one can't say we've been severely prejudiced by a lack of finality and, on the other hand, not progressed the claim such that it's left Heliopolis hanging. And that is the unusual circumstance, may I suggest, in this claim, which warrants a explanation. If I'm wrong about that and the claim against Heliopolis has come to an end, I will be corrected and I will withdraw the submission. If I am not wrong, and Heliopolis is still very much a live feature, the truth of the matter is, if this matter goes to trial, it will join up to the procedural timetable which already exists in the claim. And of course, you have evidence in the form of this application, which is perhaps, may I suggest, more full and clearer than you have in the ordinary course. There haven't been any pleadings in this case. So in terms of the prejudice that's been suffered, it's lacking. And in terms of the finality, it's questionable. And I ask you, with respect, to have that in mind. So finally this, and I will bring it to an end because I've spent enough time detaining your attention. We've said in our skeleton argument that the court should stand back and determine what the right way to proceed is in this case. And there has been case upon case upon case that talks about whether this time has been too long, that time has been too long, what position is here, what position is here. Every single case turns on its own facts. And we could pull out, even at 20 minutes before this hearing, another authority is put in front of you that talks about the particular circumstance of that case. That's not authority. That's just another example of a court exercising its discretion. That's all that it is. But every case turns on its own facts. But there are core principles that run through every single authority. Number one, genuine disputes should be disposed of by a judgment in the facts. Number two, promptness should be upheld because the court needs to keep control over the process, but it's not determinative. Number three, A lack of promptness doesn't trump the need to dispose of a case properly, unless the process is so undermined by delay. The balance of the just result dictates that the litigation should go no further. That's not this case. Fourthly, the rights to finality is important, but it's not the test. If it was, judgment in default wouldn't ever be set aside. It would never be set aside. And the court must look at the prejudice that both sides is likely to suffer as a result of its decisions, because one party in the end will be disappointed. So you have to carry out a balancing exercise. So finally this, where does the interests of the process of the claim lie in this particular case? None of the cases come anywhere here. None of the cases you've been referred to come anywhere near to what we have here. And that is a genuine dispute that cannot be resolved outside the trial process on a background of fraud and forgery. And in all the circumstances, this is a matter which cries out for a trial. And the truth of the matter should not come second place to the claimant's criticism the defendants have taken too long to get to this point. I will leave other matters to reply, but unless I can assist you further, Your Honour, that's all that I would wish to say at this stage.
Thank you for your submission. May I invite now the claimants? Yes, Mr. Patel.
Thank you. Thank you very much, Your Excellency. If I may start by referring you to the burden of proof. It has been a little lost in the submissions that have been made this morning by my learned friend, but it is critical to your approach and the test you need to apply on this application in our submission, that the burden rests on the defendants. And as the case law demonstrates, that is for the very good reason that a claimant in the position of our client who has obtained a regular judgment, meaning a judgment on default, but nonetheless an entirely regular judgment and not as suggested by Mr. Osman, some form of irregular or less complete or less meritorious judgment. It is a regular judgment, is entitled to hold that judgment unless the defendants can meet the burden that is on them to establish that there is a realistic prospect of them winning the day at an eventual trial, which means that they have a realistic case which carries a conviction that it will, in fact, win the day. And it is not the case. It is true that we have said, our client has said on evidence, and it has been made, the case has been put, that it is the bank's position that this is a dishonest fabrication. That is what the bank has said. But that is not a finding that you would make today. It would not be appropriate for you on this application to make such a finding. And for the purposes of your decision today, it is not an extreme position on one side versus an extreme position on the other, and you caught in the middle, having to decide whether the bank is correct in its perception that there's been dishonest, that this is a fabrication and made up after the fact, or not. The question is whether the defendants have met the burden of proof in establishing that they have a realistic prospect of success, and that they have not, that they are not, as a matter of discretion, in the overall circumstances, including the delay, prohibited from advancing matters at trial. And in relation to the delay, we'll come back to that, obviously, but it is the case, and under the test that is the law, that delay may be determinative, and there are many cases, including a number before you in the authorities, where it is clearly stated and illustrated that delay can nonetheless be a valid reason for a claimant to hold on to a default judgment, notwithstanding that a defendant may have identified a defense or a point of defense which has some prospect of success. So just to summarize on that opening point, I think the key two words I wish to emphasize at the beginning are that there is a question of burden of proof here, and the second, that we are not inviting you, and it would not be appropriate for you to make a finding of dishonesty against the defendant. That is not necessary for you to go that far, because what you have to decide is whether the defendants have met the burden that is on them. And it is our case, first of all, in relation to the allegations of fraud and the circumstances of fraud that the defendants have brought to your attention, that, of course, the bank is the victim of a fraud here. The bank is the one who lent substantial funds to these defendants. And if there was a fraud, it was a fraud that was committed internally to their affairs. We were a bona fide lender at all times. There was no suggestion that we had any knowledge of, or even any fact that would have put us on notice of any wrongdoing. So we are in the position of the victim of a fraud that they allege. And that answers the question of whether the first defendant, the main borrower, has a realistic prospect of success, because clearly it doesn't. All of the matters of which it complains in relation to the facility could never constitute a defense vis-a-vis the bank. And that's the beginning and the end in our submission of the idea that the first defendant should get passed today, because it has not identified anywhere a prospect of success, because we are perfectly entitled and would be entitled at trial to say, that's all very well, you've brought all those matters to our attention, those investigations may be ongoing, but there's no question before you, and nor could there be, of any knowledge on the part of the bank that would invalidate their claim to enforce the debt. And the same argument applies to the fourth, fifth, and sixth defendants, the subsidiary companies who were the corporate guarantors. Those defendants, the guarantees that were entered into by them were signed by people who had the authority to do so. There's no suggestion that they were not the correct persons. And we were entitled, as a matter of UAE law, to, as we would be under DISC law, to rely on the managers and the shareholders and directors and the persons who put forward those signatories as the valid signatories, who were in fact the correct signatories for those guarantees. And if I could ask you, Judge, please to turn in that regard to page 34 of the first hearing bundle.
34?
Page 34 of the first hearing bundle.
Yes.
And this is Mr. Ahmed Al-Mareki's first written statement. And at page 34, you'll see that he sets out the corporate ownership and managerial structure of the corporate defendants. And the first company, he described Sharifa as being the registered manager, and she delegated her signatory powers and other authorities to him and to Mr. Haider. Then at 14.2, there's a reference to the Heliopolis position. At 14.3, it explains that the trade license of Delma Engineering is currently inactive, but the partners are Miriam and Mr. Haider, and both Miriam and Mr. Haider were the joint authorized signatories of Delma Engineering between 2014 and 2017. And similarly, 14.4, Delma Diesel, it's Miriam is the 100% owner, trade license is inactive, registered manager was always my daughter Miriam. And 14.5, Delma Transport, Mr. Haider exercised, managed the company through a power of attorney, but it was owned 100% by her daughter Miriam, who was the registered manager. So likewise, the subsidiary companies, the corporate guarantors, the signatures obtained by the bank and which were important to the bank in granting the facility as being linked to it, the bank relied on those, and it was perfectly entitled in our Review A law to rely on them. And again, all of the matters of which the defendants now very belatedly raise are incapable of constituting a defence. And in our respectful submission, no defence, never mind any defence with a real prospect, has been identified in respect of any.
Yes.
The test in our respectful submission is the case law that has been identified insofar as it's being relied on. I think it is important that you take a bit of a closer look at the principles and the test that is applied in the modern cases. And if I could ask you to turn to page AB 158 in the hearing bundle, 158 of the hearing bundle. This is a summary of the principles, including in relation to delay, offered by Lord Justice Potter. I'm sorry, it's offered by Lord Justice Clark, excuse me.
I'm sorry, Patrick. I'm sorry, Patrick, I missed that reference. Would you be kind enough to just say it again? I'm so sorry.
AB 158.
Thank you very much.
This is the judgment of the English Court of Appeal on appeal from Judge Cook. And Lord Justice Clark here identifies a number of principles. Now, what you see, Judge, at paragraph 33 is in fact the summary of Judge Cook at first instance. And he said, so the court's power to set aside is discretionary. The burden rests upon the defendant to demonstrate that there is good reason why a judgment regularly obtained should be set aside. And furthermore, depriving the claimant of a regular judgment which the claimant has validly obtained is not something which the court will do lightly. And then it is a requirement that the defendant to show that it is act promptly. It means with all reasonable celerity, which really means swiftness in the circumstances. Promptness will always be a factor of considerable significance. And if there has been a marked failure to make the application promptly, a court may well be justified in refusing relief notwithstanding the possibility that the defendant may well succeed at trial. And the reference to the Standard Bank judgment of the Court of Appeal, which affirmed Justice Field at first instance in that case. And it follows that by contrast with the test for summary judgment, the merits of any proposed defense are just a factor which can be taken into account, and an unimportant or irrelevant factor where the failure to act promptly is particularly egregious. And here we see the reference to the word egregious. It's not the case, as has been urged upon you, that you should only refuse to set aside the judgment on delay grounds because there has not been any egregious or particularly blameworthy delay or significant delay. It's the other way around, in fact. It's that where the failure to act promptly is particularly egregious, that is the presumption and the public interest that is protected by the requirement that a defendant act promptly means that the test is one that's balanced in the circumstances, always balanced against the strength of the defense. And in that regard, Mr. Osman has said to you that it's very important to approach the order of the questions, first relating to the question of whether there's a realistic defense, and then secondly to have regard to delay. But that may be so, that may be logical to a certain extent, but it's equally clear on the case law, which I'll bring you to in a minute, that it's a balancing exercise, and the one may indeed very much influence the other. And we see that over the page in this case, where having set out these principles, you'll see that there's a reference to the particular time periods there, that 59 days was very much at the outer limit in one case. And then it goes over the page to say that at paragraph 36, and now this is Lord Justice Potter, or Lord Justice Clark, qualification is, it does not seem to me that the merits of any defense are ever irrelevant. The court is engaged in an exercise of weighing delay against merits, which will include considering the nature and extent of the delay, the reason and any justification for it, the strength of the supposed defense, and the justice of the case. The stronger the merits and any justification for the delay, the more likely it is that the court may be prepared to exercise its discretion to set aside a judgment regularly obtained despite the delay, and vice versa. This is not to say that a real or even a good case of merit will usually lead to the judgment being set aside despite significant delay, since delay is now a much more potent factor than heretofore. If there is a marked and unjustified lack of promptness, that itself may now justify a refusal of relief because the delay is a factor that outweighs the defendant's prospects of success. And there's a reference again to some case law. And we say, in this case, there has been unjustified and marked lack of promptness. The evidence demonstrates that Mr. Federgoli was briefed before the default judgment issued, and indeed that Mr. Ahmed had the full pleadings furnished to him through Heliopolis a couple of months before the default judgment issued. And it's also on the defendant's own case quite clear that they were advised in terms that it was highly likely that a default judgment would issue. Nonetheless, they took no action, no steps to engage with the court and engage with the proceedings. And that period of delay is relevant. It's not that period of delay is not pre-action delay, because the action was then on foot. They had been validly served. All the defendants had been validly served on the 9th of June, 2019. So that is a case where they stepped back, allowed the judgment to be entered against them. It is a case where they deliberately refrained from taking any steps to set aside the judgment, even though they had been advised, and that's on their own evidence, they had been advised that it would be necessary to bring an application to set aside the default judgment. And a period of 6 months passes without having taken that step. And it is a striking feature of this case that a case where a judgment for over $7 million is entered against Mr. Ahmed and his daughters as personal guarantors and against the corporate guarantors and the main company, that instead, as one would expect, of immediately protesting and say, hold on a second, we never signed these facility documents, we never signed these guarantees. Instead, they deliberately wait, and that the inference is there for this court to identify, that they wanted to wait to see if they could get an expert to say something about the handwriting. And they wanted to see what that expert would say before bringing their application. Not one mention was ever made in correspondence, not one indication was ever made until April 26th of April, I think, 2020, of these allegations of forgery. And that delay, in terms of the credibility of that position, must be judged against the evidence which is before you. That back in July 2017, Mr. Al-Mareki, on the contemporaneous records and evidence before you, was sitting with representatives of the bank and signed a minute of a meeting in which the debt was acknowledged, not just by the company, not just by the guarantors, but by the personal guarantors as well. And I will bring you to that minute. In addition, you have the evidence of Mr. Kumar and the evidence of Mr. Samanta, which demonstrates that back in 2015, at a time when Mr. Ahmed initially said that he had no dealings whatsoever with this in relation to this facility, had no knowledge of this loan or these guarantees, that he, in fact, was instrumental, naturally, as one would expect, as the owner of the company, in bringing about the facility. And on all the evidence, the factual evidence relating to whether Mr. Ahmed and his daughters signed these personal guarantees, their case is implausible in our respectful submission. And it is contradicted by contemporaneous evidence. And in addition, the expert evidence which they procured and now rely on does not alter the fundamental position that the evidence of the principles of they themselves is implausible and does not disclose a realistic prospective defense, even on the evidence before you today. And Mr. Osman has said that there is a preponderance of evidence, perhaps for an application, perhaps even an unusual amount of evidence for an application of this kind before you already. We don't disagree with that. But what is clear is that the bank lent the money, the company took the money, the owners and shareholders and directors of those companies never raised a question as to, how these funds had been obtained. $7 million landing into the company accounts was never said that those monies should be returned to the bank, that they'd been obtained by some form of mistake. And our client has validly obtained judgment. It took steps following the default judgment to enforce that judgment, and it has been prejudiced and would be significantly prejudiced by a further having to go back to square one and pursue this to the end. And what this court has a duty to consider, not just to simply stop at the point of saying, oh yes, there's a dispute as to fact, I can't resolve that now. That's not the test. The test is that you are required to take a look and to come to your own decision as to whether at the end of the day everyone is more likely to be back where they began, with the bank having obtained a judgment against these defendants with all the costs and delay and prejudice that results in the meantime, including to the defendants themselves. So, Judge, if I might bring you next to just a few of the other cases before coming back to my submissions on the evidence.
Yes.
Maybe if I might just perhaps get the legal principles identified on the basis of the case law. I'll try to be quick.
Please.
Thank you. If I could next turn to please to AB 104.
AB 104. Yes.
Yes. And this is the UTEX Africa, International Finance Corp against UTEX Africa case. And I just refer you please to paragraph 8. That this is the reference to the Saudi Eagle judgment, which has also been referred to.
Yes.
And here, and that's at AB 035. I'll just give you that reference now for a cross-reference purpose, Judge. AB 035 is the relevant passage from the Saudi case, from the Saudi Eagle.
Yes.
And there it's clear that it is not an arguable case. The test is not an arguable case. The test is that there's a real prospect of success, as the statutory language states, and that means that the defence must carry some degree of conviction. A realistic prospect of success means a case which carries a degree of conviction. And that there has been, I think you've got to be a little bit careful of the written submissions that have been made in the skeleton by my learned friend. There are many references to arguable case, of course, which is not the test, nor is the test the one that applies to a test for immediate judgment. The test is the one that we've identified in this case law. And if I could ask you then to turn to AB 038.
Yes.
This is the judgment of the Court of Appeal, English Court of Appeal in ED&F Man Liquid, and this is the Lord Justice Potter case. And the headnote is helpful in this case. It refers at point 1, bottom of page 38, to the burden of proof. And then it goes on to say that, and this is Mr. Osman has cautioned you against conducting a mini-trial, but if you look at the point 2 on page 39, while it is certainly the case that the court is in no position to conduct a mini-trial, the court does not have to accept without analysis everything said by a party in his statements before the court. In some cases, it may be clear there is no real substance in factual assertions made, particularly if contradicted by contemporary documents. And that is on AB 041, a few pages on, you'll see that.
Yes.
Paragraph 10, about 4 lines or 5 lines down, you'll see the reference to particularly if contradicted by contemporaneous documents. Of course, a general principle of evidence and adjudication. And you'll see then at paragraph 11, which corresponds to point 3 of the headnote, where there is a claim for judgment for monies due and issues of fact are raised by a defendant for the first time, which standing alone would demonstrate a triable issue. If it is apparent that, with full knowledge of the facts raised, the defendant has previously admitted the debt and or made payments on account of it, a judge would be justified in taking such acknowledgements into account as an indication of the likely substance of the issues raised and the ultimate success of the defence belatedly advanced. And we rely on that, Judge, because that's precisely what happened in this case. We have, despite inherently implausible and now it appears statements that have been already rowed back on by Mr. Ahmed when it was pointed out that he did attend certain meetings. But we do have contemporaneous evidence stamped by the company seal of the first defendant and handed over in a meeting which our clients say took place in late July 2017 and was followed by, again, contemporaneous confirmation or letter written to a third party asking that third party to pay money to IDBI, to the bank, because of the, in turn, agreed indebtedness of the company to the bank. And as we'll come to that again, but I'll repeat it again, that the contemporaneous evidence there is crystal clear that the bank was calling on all of the defendants, not just the first defendant as the borrower, but also on the corporate guarantors and also on the personal guarantors, and was maintaining contact with all of them and reminding them of their liabilities, and was engaged on a very determined exercise to get proposals from the defendants as to how they propose to deal with the debt. So that is all that's on the record, and in our respective submission is very important on the basis of an acknowledgement that features very strongly in the evidence on this application. I think, Judge, I'm not going to open any further cases. If I could just simply refer to some of the principles that we've identified in our skeleton, and just to call attention to some of the to the page numbers.
Yes.
You'll see the Standard Bank is a judgment of Justice Field, and that's the additional, I think that was added towards the end of the bundle. I think it's AB 251, the very, very last page of the bundle. You'll see at paragraph 26 to 29, there's an analysis of why the default judgment was not set aside in that case, and of course Justice Field's judgment was affirmed by the Court of Appeal. There and in other cases, you will see a very strong affirmation by the English courts that the delay of one's legal team or any other advisors is in fact the delay of the defendants in any particular case. And the reason for that has been explained in the case law, is that the test under Rule 14 is whether the defendant has been prompt in making the application, and the defendants are, as a matter of policy, not permitted to hide behind the inaction of their advisors or their legal team. So that aspect of the excuse offered by the defendants, to the extent that it is offered, doesn't hold any weight. Similarly, the explanation that they chose to allocate resources from one case to from some other cases and away from this case is, on the facts, first of all, implausible, because it only costs $300 to make a set-aside application. If they were having difficulties with the retainer, if they wanted to save up and brief a barrister, if they wanted to devote resources elsewhere, those are matters that could have been brought to the attention of the court on an early application. But really, it is implausible. And the true position, which is quite clear from their own evidence, is that they deliberately chose to wait because they wanted to see what an expert would say about their handwriting. And again, it's important in our respectful submission that this was never once ever raised in years of dealing with these defendants in relation to their liabilities to the bank. So, if I might
yes.
Then also say that from the cases, and you'll see this from a number of the cases, from the Lord Justice Clark judgment in Regione Piemonte, from the other cases I've mentioned, DDF Mann and the UTEX Africa case, but also others, the Core Export case, Mullock, Khan, and Regency Rolls. There's a clear preponderance of cases where it is now well established that delay on its own may defeat a set-aside application, even though there may be a realistic point of defense that might have been identified. And if I could also say that allegations of fraud, even where they're made against the claimant, those themselves are not immune, or those, they don't stand in a separate category. And you see that from the Khan case and from the Gentry case, that they were cases where allegations of fraudulent misrepresentation or fraud were advanced by the defendants in seeking to set aside default judgments, and the courts affirmed that they were in no special category, and that indeed they weren't of themselves capable of overcoming the delay and the overall considerations of discretion. And of course, in our case, we are in a different position anyway, because the fraud isn't even alleged against us. We are the victim of fraud in this case as a result of matters internal to the defendants, for which the bank has no answer, which the bank had no knowledge of or had no notice of, and therefore the ordinary rule applies. I'd like to say also, just in relation to the evidence of the experts in this case, there is a principle which, to start at the beginning, when one is considering what weight to attach for the purposes of today to the expert evidence, that the mere expression of opinion or belief by an expert, however eminent that expert may be, it will never suffice. That applies particularly in the present case to the second report of Dr. Alba, because just to recall what happened here, Dr. Alba examined the sanction letter signatures in his first report. Then when Ms. Barr submitted her report, he then submitted a second report, but didn't actually carry out any analysis at all in that second report. And while sort of promises that such an analysis will be made in the future, there's nothing before the court today underpinning his conclusion or explaining it, that the declamatory and definitive conclusions that he's reached are that these signatures were forged in the Mashrek mortgage document, the 7 checks from Mr. Ahmed, and indeed the signatures of the defendants on the facility agreement and the guarantee agreements. And remember, the facility agreement is the agreement to agree. The sanction letter is the agreement to agree. The actual facility documentation and the guarantees that issue in this case are the later documents. And in respect of those, there is no analysis carried out by Dr. Barr. And as I say, there is a declamatory and surprisingly absolutist conclusion reached by him. And you'll see that in the second report, where he really just says these signatures are definitely not the signatures of the defendants, without more. And the mere expression of an opinion, as I say, by any expert, no matter how eminent, doesn't suffice. In fact, it's an argument can be made, a strong argument, that is almost, it is barely admissible as evidence, because remember, opinion evidence of an expert is an exception to the rule against opinion evidence, and it is allowed in by a court only in circumstances and on conditions that are based upon an expert analysis. And so it is really taken in the round, in our respectful submission, Ms. Barr's careful, calibrated, analytical approach is far to be preferred, because the care that she takes in assisting the court is the true approach that an expert should take in a non-partisan and a informed, analytical, accurate way, with internal consistency, taking care to set out the reason for her conclusion, entirely absent from the second report of Dr. Barr. And if you need authority for that, I don't have it before you today, Judge, but It's in the medical law reports, and we tried to get it, and I can furnish it to the court once. I think we will probably have it later today. There's a case of Loveday, Love Day against Renton, and I apologise to my learned friend for not bringing this to his attention before. But perhaps if the court would allow me to make that reference, and if any submissions are required on it after the hearing, of course, we
I will allow any authority to be submitted after the hearing, just the authority, that's fine, for both sides.
It's called Loveday and Renton, and it's 1989, one medical law report at 117. And that's the judgment of Lord Justice Stewart, which you find referred to in many of the leading texts. So, what we say about as I said, we said in the skeleton argument, a lot is being made of this leading document inspector who has come forward and on the basis of which the defendants have put in their witness statements in April 2020, raised for the first time. But considered in the round against and balanced with the weight of those expert reports insofar as they are, this is not an application in which you have to resolve the differences between the experts on the handwriting. This is a case where you are required to look at the evidence as a whole, balance the significant and, in our submission, wholly inexcusable and inordinate delay on the one hand, against what real weight there is in the point of defence that's been identified. Point of defence revolves around an allegation made for the first time that these defendants never knew anything about these facility agreements, never knew anything about the guarantees, and that their signatures are not genuine, and that therefore they must have been forged. And it's interesting, even the way in which that's presented on the evidence of the defendants. They put it forward as a case where, we now have this expert evidence which says that these signatures aren't genuine, therefore they must be forged, and we've never heard of them before. But it's the putting the cart before the horse in the manner in which the entire evidence is presented so late in the day does raise significant questions about it. And that, without making a finding of dishonesty or being required to analyse how or why that is, does undermine the plausibility of the case that is being advanced by the defendants, and it's not greatly improved, to be honest, by Dr. Alba's report. In fact, when compared to the more careful approach of Ms. Barr, it all gives the impression of having been hastily put together to reverse matters very, very late in the day. I can turn now, with your permission, Judge, to HB3. That's the evidence bundle behind the affidavits, or behind the witness statements of Mr. Kumar and Mr. Samantha. Judge, have you had an opportunity to read the witness statements?
Yes.
Yes, okay. I do obviously rely on the evidence of the two bank officials who have given evidence on behalf of the bank in this case. Mm-hmm. And I ask that you do please pay, that they be fully taken into account in your ruling.
Yes.
The evidence on which they exhibit includes, there's quite a bit of duplication because of various different copies of the documents. But I think there are three particular documents that I can bring you to. The first one is at HB 315.
Yes, 15.
Yes. And this is the document that's referred to in the evidence as being the letter written by the bank to Mr. Al-Muraiki, as chairman of the group. And it sets out in a comprehensive way the facilities and the guarantees. And you'll see on the first page that the facilities extended to the company are secured by cash margin, etc., and mortgages, corporate guarantees at about 4 lines from the bottom, corporate guarantees of Delma Engineering, Delma Emirates General Transport, Delma Emirates Diesel, and Heliopolis, and then personal guarantees of Ahmed, Sharifa, and Mariam. And then it says, as you're aware, there are overdues in the account since the 1st of April 2017, aggregating to $1.83 million US. And then it goes on to draw attention at paragraph 2 to the defaults for non-payment, and that this will force us to initiate legal action and recovery measures against the company and the guarantors, besides taking the following actions. And then it says at point 3, the matter has been discussed by us today with you over the phone. Sensitivity of the matter was suitably explained to you over the phone. We have also sought a convenient time for meeting you on an urgent basis and requested to organise the payment at the earliest. And then it says at point 4, we're also keeping the personal and corporate guarantors apprised of the matter. And you'll see at the end of the page, the corporate guarantors are identified and the personal guarantors are identified. And importantly, Your Excellency, you'll see there the stamp of Mabani Delma General Company, LLC, at the end of that on HB 317. And that is the stamp that is referred to in the evidence on behalf of the bank, that this letter was being pressed by the officials of the bank for to be countersigned, to be acknowledged by the defendant, by Mr. Ahmed, and eventually at a meeting that took place on the 27th of July 2017, the evidence on behalf of the bank is that this letter with this stamp was passed over the table by Mr. Ahmed directly to Mr. Samantha. So that is an acknowledgement and contemporaneous evidence of the existence of the facility, the existence of the guarantees, and taken together with the evidence of the meetings that took place is significant evidence in the case, which undermines the allegation of the defendants that they knew nothing about these facilities. And then you'll see at HB 318, you'll see Mr. Rai for Delma Group is sending to Mr. Samantha a letter addressed.
HB 13, you said?
HB 318, Your Excellency.
18, yes.
Mr. Rai is sending a letter to the bank,
yes,
saying that the original letter was taken to their office today, and this is a letter addressed to the third party, Larsen and Toubro, to release payment directly to your account. And then a few pages on page HB 323, you see a copy of that letter dated the 6th of July,
Yes.
in which the third party is asked to pay the bank directly for an outstanding payment of $30,000, which is acknowledged due to IDBI. Now, those documents are repeated a number of times in the evidence in HB3, but I bring you forward to HB 344.
Yes, 44.
And this is the minute of the meeting that was held on the 29th of June 2017 between Mr. Kumar and Mr. Samanta on behalf of the bank, and 4 representatives of the Delma Emirates Group, including Mr. Ahmed, including the finance manager, Mr. Rai, and Mr. Pillay. None of those, I think, none of those officials are the officials against whom the fraud is alleged. And you see that this sets out what was brought to the attention of the representatives at the meeting on the 29th of June. It's a minute dated the 5th of July. It was a $7 million loan, irregularity of $2.92 million owing, and then the defaults are set out, the interest, etc. And at point 3 over the page, the difficulties faced by the borrower were explained by the chairman, Delma Emirates Group, and that's Mr. Ahmed, when it was informed that one of the reasons for not making the payment to the IDBI was that the group had been facing labour issues, which is before the court, such its accounts are frozen. Due to liquidity problems being faced by the company group, there have been overdues with other banks too, who have been approached for providing a moratorium of 1 year, which are under consideration by these lenders. The company also sought a similar treatment from IDBI with regard to its dues. And Mr. Al-Mareki also touched upon the matter relating to induction of the new investors into the group, but did not disclose the details due to sensitivity of the information. And then in paragraph 4, it goes on to describe the chairman requesting IDBI in terms about 5 lines down not to initiate legal actions, as it will not lead to any solution, and that the company and the group was committed to honour its obligations. And that minute was furnished to Mr. Ahmed. Again, you have the evidence of Mr. Kumar and Mr. Samanta directly in relation to that. So it's our respectful submission that the allegation that is now made that the defendant knew nothing about it is implausible in the light of that direct contemporaneous record. And it's also implausible that the owners of these companies, the managers at the time, the shareholders, the directors, would have been unaware of the obtaining of a loan for $7 million by the principal company, or of the guaranteeing of that loan by the subsidiary companies. And in that regard, it is not the case, in our respectful submission, that the defendants have met the burden of establishing that the criminal investigations of which they've pointed to extend to these facilities. There is no police complaint before this court in relation to these facilities. There is no document, that stands to be corrected, but it appears that there is no document, including the document referred to in Dr. Al-Ba's report, that demonstrates that these facilities are the subject of any investigation by the police or by the prosecutor on shore. And one would have expected, the burden being on them, that the defendants would have identified any document or come forward with any proof that specifically these facilities were the subject of a complaint, and that this $7 million loan was obtained by means of fraud against them. We also have, on top of that, Mr. Al-Mareki rowing back from in the face of evidence which are just open to you, and in the face of the also the evidence of direct evidence of our clients that they met with Mr. Al-Mareki back in 2015 when he was procuring these facilities, that he said he indicates that 2015 meeting could have taken place, that he couldn't rule it out. And that's not just a minor concession or a minor rowing back of the position. Mr. Al-Mareki and his daughters have come to this court asking this court to believe, as a central feature of their position, a fundamental fact of their position, that they never knew about these facilities, that they never met any of the bank's officials in relation to these facilities. And they repeat that in identical terms, in a type of cut and paste way, in the evidence that they've advanced to this court. Yet Mr. Al-Mareki, as the principal, has now conceded that that's not the case, that he may well have met the banks. And this court is entitled to draw an inference that it is implausible that a business man would forget meeting bank officials in relation to the taking out of substantial lending, which was then acted upon when that loan was actually procured and the money was handed over and the bank is now seeking to recover it. This court is a commercial court. It is an international commercial court, and it expects commercial parties to adhere to commercial standards as well as to provide full evidence of their dealings in relation to the matters that they're seeking to persuade the court of. And that is reflected in the case law. We've seen that, and Mr. Osman referred it to you, that there should be full evidence before the court. I think this Abisa case was one of those. But they have not done so. They have not been candid. They have not disclosed the existence of meetings which, on the evidence before you, must have taken place, and that were instrumental in giving rise to these loan facilities.
Okay. Yes, Mr. Patrick, any further points?
I think, Judge, there's one last thing I should address you on, and that is that the jurisdiction that you're exercising under Rule 14.2 does allow you to exercise your discretion on such terms as you think fit. If you are, if, for example, you were to take the view that there was no defense disclosed, or no reasonable or no realistic defense carrying conviction of the main borrower or of the corporate guarantors, but if you were to take the view that there were an issue in relation to the personal guarantors, and I say that you shouldn't, because they're intermingled, of course. They're the same signatories, they're all caught up with each other, the implausibility, all the things that weigh in the balance. I say you should not do that. But if you were to take that view, then we submit that you ought to give consideration to the conditions that would attach to any decision on your part to allow the personal guarantors to continue. And the financial, the weakness of their case, the implausibility of their case, the doubts that must be extremely real in this case are relevant to that, and that's you see that in the case law as well. You see in the Swain case itself at AB013, you'll see where Lord Justice Judge says, yes, well, if there's a different discretion that arises, if you're satisfied that the case should continue or that the judgment should be set aside, a different discretion arises then as to what conditions you should impose. And in our respectful submission, the personal guarantors there will be a judgment following today. There ought to be a judgment, a default judgment that continues against both the borrower and the corporate guarantors. But the personal guarantors, because they are so caught up with that debt, and because the personal guarantors may be, in the light of all the different difficulties being encountered by the group, they may not be a mark ultimately for the judgment against them, that will be important for the court to consider what money they should pay by way of security as a condition of being allowed to continue with their claim, with their defense. And it would be an injustice in our respectful submission where they, in circumstances where they may be the only true mark for the judgment and for recovery of the loan on foot of the personal guarantees, that they would be allowed to simply continue on their merry way without conditions being attached, substantial conditions. And if necessary, in our respectful submission, there could be an inquiry by you into their means and into the appropriateness of security being required for that purpose.
Okay. Yes. Any further points before we turn to the applicant?
Well, Judge, I think to return to the questions that we've identified and the sequence of points that we've identified in our skeleton argument, I think that's probably a good place to end. We've emphasized the burden, we've emphasized the acknowledgement, and we've emphasized the overall weakness of the point of defense that's been identified in the light of the evidence as a whole. Mr. Osman and the defendants invite you to say, well, this is an adjudication now on the facts which can't be arrived at on the evidence. That's not the case. You have sufficient evidence before you to exercise your discretion. There is no need to come to a conclusion on the fraud. There was no need to come to a conclusion on what we say is a fabrication. You just simply decide whether the defendants have actually met the burden that is on them in all the circumstances for the default judgment to be set aside. And in that, you balance the significant delay against the weakness, as well as the weakness of their arguments and the implausibility of them, and ultimately carrying the day. And consider also the relative prejudice. And on that last point, on the relative prejudice, you'll see in the case law as well, naturally, and you'll see this in the Gentry case, I think maybe also in the Khan case where they consider fraud. But the courts have said that at a certain point, the question of whether there's been fraud and the remedy of people in the position of the defendants to against the fraudsters is something which they should take elsewhere, because this judgment stands in any event. This judgment should stand in any event, and their remedy is against fraudsters elsewhere. And that's part of the balance of convenience. On our side, nothing is to be gained, we say, by forcing the bank through the process of proving its claim following a full trial against the personal guarantors, when that is, in our submission, quite plain today that would be prolonging the agony. And you should grasp the nettle now, as some of the judges have used that expression, and rule that the default judgment should be held on to. Those are my submissions.
All right. Thank you for that. We may now go back to Mr. Osman for his reply.
Thank you. I'm slightly troubled because I know you said you had an urgent application and that we'd be listed for 2 hours. I'm not going to take long in my reply, but I have an eye on the fact that you have that urgent application.
That's fine. Still, we have 1 hour if you want to go any reply.
That's an invitation you should never give a barrister.
Yes, no, that's fine. You already paid for that, for 3 hours hearing.
Thank you very much. Well, in any event, I won't take too long because, as I say, a lot of the material has been traversed. But may I say from the outset, there are some eyebrow-raising submissions just made by my learned friend, and I want to go through them. What I'm going to do is this: I'm going to address a few of the points that my learned friend has raised, and also just take a fairly cantorous approach to the case law. Because as a very experienced judge who has no doubt seen a lot of these authorities before, you don't need to be taken through each one of them line by line. So I'm going to highlight the relevant principles. But in terms of what my learned friend has said, here are the eyebrow-raising points. A concession, may I suggest, that there has been fraud in the background of what's taken place here. And his words are effectively, look, the bank are a victim of a fraud that's been perpetrated by the managers of these particular companies. And the reason why I raise that is because that is now the established context from which you must proceed. That is what has taken place in the background in respect of the situation that is in front of you. And that is a troubling situation when it comes to a request to effectively put away any idea that the matter should be properly investigated at trial. So that is something which I ask you to have in the forefront of your mind. The sanction letter. There is a lot said about the ex post facto effectively fallout of what took place after the collapse of the DEG group. There is very little in respect of what took place at the beginning when the facility was purportedly arranged, and that was predicated by the sanction letter. Can I ask you to kindly turn to Hearing Bundle 1, page 146. So that's HB1 146.
Yes.
And it the section reads, unsurprisingly, sanction letter. And here is what we say about that. The claimant hasn't produced any evidence challenging our main submission that we did not execute the sanction letter, and the signatures that appear in the sanction letter dated the 21st November have been forged. I pause there. At the time Dr. Al-Bar conducted his initial assessment in respect of the analysis of the documents, the sanction letter was the main item. That was the main event that was looked at as to whether it had been forged or not. And that is the preeminent document, may I suggest, in respect of how the facilities came about. Mr. Al-Mareki goes on to say the claimant is silent about the circumstances of the execution sanction letter, not provided any details regarding where and when the sanction letter was purportedly executed, or the names of the claimant's employees that were engaged in the sanction letter. No evidence that they took any steps to contact me or my daughters. And the allegation I met IDBI and I agreed to provide the accepted sanction letter is just not particularised or dealt with in the evidence. And so what my learned friend has, may I suggest, deftly and skillfully done, no doubt because of the experience and charm that he has, is he has shifted the spotlight as to what took place in this case to after the collapse of the DEG group, and what Mr. Al-Mareki did when he came to be speaking with the bank's employees, who said, look, this is something you have to pay now. And he criticizes Mr. Al-Mareki by saying, well, he's changed his account. He's now saying he probably did meet with those individuals. Well, he's dealt with that in the evidence. And that you can see is at page 31 to 32. And let's not remove the context from what took place. In paragraph 31 on HB1 151, he says, in mid-2017, as part of my attempt to save the Delma Group from collapse, I met routinely with several bankers and other creditors. It's correct to say that I provided reassurances of the Delma Group being repaid its debts in good faith. And at the time, we were trying to fend off a series of attacks on our integrity. We did not have a clear picture of the extent of the fraud that had been perpetrated against us. And he goes on to say that he does not specifically recall discussions. He doesn't exclude the possibility that's correct. But it's in no way dispositive of the claimant's claim, because what matters is what took place at the beginning when the facility was arranged and that sanction letter. But there is very little examination of that part of what took place and that chronology of what happened. And the claimants have been assiduous in terms of focusing on what they say took place after the bank says, now you have to pay, and what Mr. Al-Mareki says is that he was trying to fend off the attacks that were taking place, and he wasn't at that stage knowledgeable about the fraud and forgery that took place. The point is this: these are, and forgive me, there is one very important point, of course. You will see from his first witness statement, and I can take you to it, but it's not necessary, the travel logs where he wasn't even in the UAE at the time the original sanction letter was consummated. And these are important matters which need exploration. What my learned friend has done is he's made a series of trial submissions to you as to why his case is to be preferred. And that is the difficulty in dealing with this case at this juncture, at this point. There are no pleadings. In fact, there's a direction for particulars of claim to be issued by the registrar when originally judgment in default, the application for judgment in default to be set aside was given, but has now been removed. So we are dealing with a situation where the case has not been properly pleaded out. There are material issues from both sides that simply need to be dealt with properly. There is a focus on the ex post facto events when there should be a focus on the primary events as to when the facility agreement was properly arranged. And where there is criticism about the expert evidence, Dr. Al-Bar, what my learned friend has done is he's tried to effectively diminish his expertise, on one hand saying that he is preeminent, and on the second hand saying that he's not done his job properly. That is a remarkable submission. Dr. Al-Bar studied the signatures of all the defendants who have given evidence in this case by meeting with them and looking at those signatures being done in his presence. Miss Barr, who's said to have taken a more dispassionate and careful view, did not have that opportunity. But it's another example of the fact that where you have two witnesses and there are points to be made on both sides, in respect of Miss Barr, I've made my points. In respect of Dr. Al-Bar, my learned friend has made points as to why he shouldn't be preferred. How on earth, I ask rhetorically, is this court supposed to make a proper determination as to whether the issues have been properly dealt with and litigated when we have not even had the cases set out in terms of pleaded out cases, or the evidence has not been properly dealt with by way of the service of various witness statements? And there is a point that flows from that as well. Every time my learned friend says, well, Dr. Al-Bar should have done more, he should have conducted a better review, he should have been more comprehensive, there's more work for him to be done, there's more evidence that should have been put before you, is an acceptance that the claimants were right to go to him first, because without that, there would not be the evidential foundation to make this application. And they are vindicated in that reproach. Can I deal with another rather surprising choice of words by my learned friend? As charming as he is, he has said as follows: it will prolong the agony to allow this trial, to allow this matter to continue to trial, and for judgment in default not to bring an end to what has taken place. You will have noticed, and I have no doubt you are watching and listening very keenly to what's been said, that there is no mention, despite my invitation, as to the progress of the claim in relation to Heliopolis. And there has to be an acknowledgement that where the agony is to be prolonged, that is at the very least tempered by the fact that the claim is not over. And there is a long way to go in relation to the claim against Heliopolis. So the agony itself is perhaps not as profoundly felt by my learned friend as he suggests that it might be. And that really is the context of where you have to, what you have to look at in terms of whether it is right to do the right and proper thing, I suggest, and have this matter properly dealt with, pleaded out, and for the witnesses to be examined properly in the ordinary case by way of an ordinary trial process. And to say that there isn't the spectre of a defence at all to be raised, that has been raised by the defence, it is devoid of reality. Plainly there is. There is instances accepted by my learned friend of the bank being victim of a fraud by way of the management. That in itself is profound. There is, no matter how he wants to put it, evidenced by an expert witness, Dr. Al-Bar, which seriously calls into question what's taken place in relation to the signatures. There is a lack of evidence as to what happened when the facility agreement was first created by way of the sanction letter. My learned friend has not mentioned at all how he proposes to deal with the two witnesses who are at the company. One of them has produced the schedule of records as to people turning up on the material day, and the attendee who says he attended the office isn't present on that schedule at all. There is contemporaneous alibi evidence of the fact that that Mr. Al-Mareki was not even in the country when the original sanction letter was applied. If that is not a basis for determining, for suggesting, or indeed for establishing that there is a defence which is credible enough to pass this particular stage, I ask rhetorically, how much more does one want on the basis that we're not dealing with a full trial here, and I have to deal instead with my learned friend making trial submissions on why his case is better. I'm going to deal very briefly with the law, because as ever with law, and this is what barristers do, they pick out parts which support their case without a full better reference to other aspects in the authorities. Can I deal with them this way? Regency roles. And the authorities bundle, please, page 90.
19.
90, forgive me, 90. It's my accent, forgive me.
Yes.
I just want to highlight paragraph 40, and I'm trying to do this in a fairly even-handed manner because these are authorities. Paragraph 40, but even if he acted promptly, his case remains an incredible one. If in these circumstances the court was to require a new trial, then the misfortunes of cost and delay, which had already overwhelmed this action, and in all sense the litigants in it, would simply be extended and redoubled. This case was in relation to a trial where effectively the defendants failed to appear, and judgment in default was entered, and what was being asked for there was for the whole trial process to be run again. Now that obviously is a different circumstance, and in terms of the promptness of issuing an application to discharge judgment in default, the court quite rightly looked at whether the defence was credible. But what really mattered in this case was the fact that if judgment in default was set aside, the whole trial process would be reset. That's not the position here. We are far, far earlier in the process than what took place in Regency roles. The delay in that case is in a completely different context. We're talking about a delay where, again, that trial process would have to begin again. It's not comparable by any means as to what we have here. Authorities bundle, page 99.
Yes.
I don't have to go through this in much detail. This was a decision by this court. I think it's Mr. Justice Giles. It is, yes. Yeah. I just want to make one narrow point here. There was criticism by Mr. Justice Giles that throughout the judgment, but in particular paragraph 10, that the evidence wasn't of a standard in order to properly stand up to an application for discharge of judgment in default. The point is this. Again, it returns to the fact that when you make an application for judgment in default, you have to establish it by producing evidence. Of course, we accept that. And that evidence, in this case, required an examination of the signatures, and that is why they went to Dr. Albar first, and the time it took for Dr. Albar to produce his report. In fact, as I've said, my point is bettered by my learned friend's response, because his allegation is that Dr. Albar should have done more in the circumstances. Well, at the time he wrote his report, the document he had in his hand was the sanction letter, and by the time he had his second report, further documentation was received for him to do work. So it doesn't really lie in the mouth of my learned friend to say that the delay was unnecessary or unjustified because we had prioritized Dr. Albar's evidence. In fact, on my learned friend's own admission, his evidence is rather critical to this whole process. So the approach is vindicated. Standard Bank 113, Authorities Bundle 113.
Yes.
I'm just going to rest on the head notes. H, bottom of the page. Agri investor applied to have judgment set aside on the grounds that a real prospect of successfully defending the claim. Judge considered that agri investor had a real prospect of successfully defending the claim, but held it failed to make its application promptly. This is, and you'll see this in a couple of occasions in relation to various examples. This was a lengthy delay. This is we're talking about years as opposed to weeks or months. And of course, and you'll see that this in the first sentence, SB obtained judgment in default a year later. Agri investor applied to have the judgment set aside. Now, a year later is a long time. And when a year later starts to apply, you are approaching the territory of a prospect of a successful, having a prospect of successfully defending a claim at trial. It plays second place to that sort of delay, a delay of a year. So let's have that context in mind when we consider the authorities that my learned friend relies on to establish a proposition that even if you have a prospect of successfully defending a claim, that you can still lose if there's been delay. Sure, if there's a delay of a year. Mullet price, 130. Same bundle. 130, 130.
Okay.
I can summarize this. This is a case which is also called the Elms Hotel Restaurant Limited. In this case, the court again was dealing with a very lengthy delay, years instead of months or indeed weeks. But what it did in this instance is it took a balanced approach to the defendants, to the parties' positions, and part of that balanced approach was the fact that it had very much in mind that the defendant, who it disallowed an application for setting aside judgment in default, could actually refer to a compensation scheme, and that would mitigate the effect of judgment in default not being allowed in these circumstances. On the other side was without being rude, an elderly lady who would have to go through the process of establishing her claim again, and there'll be a lot more work for her to repeat. Again, an entirely different scenario to what we have here. But the point of the matter is this, and this authority shows it. The court looked at, because it's a discretionary remedy, a balancing exercise in relation to which party will suffer, and whether that assessment ought to weigh in favour of one party or the other. But it's certainly not authority for the proposition of anything else other than lengthy delays are not something which the court looks upon well when it comes to applications of this type. But it supports my proposition that in fact what the court will do was look carefully at the effect of the delay on the parties. Khan and Edgbaston, 136.
So do we need to go through all of those authorities? Because
No,
we can repeat the same things. So can we summarize what you would like to?
Absolutely, I will do that. And I certainly don't want to take it. I will. This is there's two more. This one and another one.
Okay.
136. And the reason why I'm relying on this is because this is actually a very useful authority. Paragraph 16, because it sets out the court principles in how to approach this. A, while the length of delay of the defence must be taken into account, any pre-action days are relevant. I think we both agree about that. B, any failure by the defendant to provide a good explanation is a fact to be taken into account when deciding whether or not to set judgment aside. But such delay is not always a reason to refuse setting aside. C, primary considerations of whether there's a defence with a real prospect of success and that justice should be done. Prejudice has to be taken into account. And I take the decision to mean that in the round, the existence of a real prospect of success may often, but not always, be sufficient to set judgment aside, even if the defendant had not acted promptly in seeking to have the judgment set aside. A lengthy delay in that case, again, against years as well. I'm not going to take you to them. But the other authorities which my learned friend refers to, one's called Agri Invest, and of course Gentry Miller, and Region Piermont, are dealing with lengthy multi-month, multi-year delays. And so they're not directly comparable to what we have here. Where does this leave you? And can I conclude by saying this? It comes down to the same point that I started with at the beginning of my submission. This is a discretionary exercise. There is no hard and fast rule as to how long is too long or how short is too short. And the authorities have been very careful not to set a time limit. This is not limitation periods. This is entirely different. And the task before you, with respect, Your Honour, in terms of how to approach this matter, is perhaps instinctive more than it is anything else. Is there, at this point, an ability by you to be confident about the fact that the matter should be disposed of at judgment in default? Or is there a basis upon which a defendant has put forward, which does not have to be a complete defence, because it never can be, because we haven't got to that stage, which allows you to consider that this is a matter which really should be dealt with during the trial process. And if you make that decision, are you being terribly unfair in relation to the claimant by prejudicing them in such a way that it's unconscionable or indeed egregious? My answer to that question is no. And Heliopolis matters for that regard. And secondly, even though my learned friend has tried nobly to say that the prejudice has been extreme, it's been unconscionable, and so forth and so on, there isn't any real evidence of the fact that the prejudice caused by him will be so extensive that a trial should not happen, other than, of course, that they would not be able to take advantage of judgment in default and will have to deal with this in the ordinary way, and that's through a trial. Those are the short submissions I wanted to make in reply. Can I help you with anything in particular?
Yes, thank you for that. Just if you want to comment on the claimant's remark about if there are any criminal proceedings has been filed against or by the defendants based on the Mr. Albah report.
As I'll take instructions about this, and I'll need to come back to you because I don't want to venture to a guess. So can I come back to you on that point?
Yep.
All I would say is that the criminal proceedings per se, in relation to what took place at the company, are ongoing and are extensive in relation to what the managers of the company had been up to. So it's still open-ended. They have not been completed. That I can say. But the specific inquiry, would you be kind enough to allow me to come back to you on that?
So you will get back to me?
Yes, I'll need to take instructions on that. Yeah. Can I do that by way of emailing you in due course?
Well, okay. You don't have your counsel assistant or your client. You cannot answer that right now.
I'll try.
It's very simple. Whether there is any criminal case has been lodged by the Dubai police, or this has still not been. This wasn't the option right now for the defendant, or they are still considering their options. If there is any criminal case or something like that, well, that will be useful to know.
I'm just receiving messages as I speak.
Yes.
There are no specific criminal allegations advanced in relation to IDBI. They are under consideration, and they are consideration will be whether they will form part of the fraud that has already taken place in relation to the managers of the company.
So can you just remind me the report, the expert report, when that was filed, or when did you found that there is some forged signature? Which month?
The expert report from Dr. Albal was filed and submitted in April.
Yeah.
And I can take you to that report.
No, I just want to
sure.
Understand why there has been now more like more the 4th month for not taking any action. Oh, yes. Okay, so you don't have any further comments on this, I believe.
No, unless I can help you with any answers to any questions.
No, I think I have. Yes.
I just I omitted to make one point in relation to the Heliopolis question, and I apologize for that, and wonder if I might just make that point very briefly with the.
You can make a point, and I will go back to the defendant to reply. Yes.
Thank you very much. I'm very grateful, Justice. The point is that in Heliopolis, the judicial guardian for the company, and the issue of the signatory then of the people and the genuineness of the signatories doesn't arise, because the point that Heliopolis raises is that the proper signatory was the judicial guardian. So the issue, it's true that there'll be some form of satellite proceeding going ahead if that case does go ahead, but it's not the same issue, because evidence will be entirely different and the issues will be entirely different, as I understand. So it's not a relevant consideration in my respectful submission that there'll be some element of the wider proceedings that will go ahead, because these issues will not arise in that continuing part of the action.
Okay, any reply?
It's the same claim in relation to the same facility.
All right. Well, then thank you for both of you for your submissions. I reserve my judgment on this until you will be informed by the registry about my decision, with reason, of course. So Ayman or the registrar will email my decision in due course.
I'm so sorry. Can I just? This is difficulty with doing things remotely while we're in different countries. My solicitor has quite rightly asked me to clarify the point that in Heliopoulos, the allegation is that Mr. Al-Mareki was the signatory, and I think that's a point that is worth.
All right.
Thank you very much.
Thank you for your time. Ayman?
Yes, Judge Shamlan.
Yes, I think we've done today for this hearing, and
Okay.
thank you for that. Thank you for both counsels.
Thank you very much, Jeff.
Yes.
Thank you.